Okay, so I want to explain something about I don't know what the theory is behind this or the whatever psychological science or whatever, but basically it's the idea that if somebody is around people they believe to be authority, like a judge or lawyers, or even judges and lawyers are around people they think is authority or that has some kind of power over them, the way they act. Okay, so but before you get put in the court system, before you're in court, before you have a court date, like there's certain things that need to happen. Like people who are innocent of a crime or innocent, period, don't need to be in front of a judge and a jury and a lawyer and a prosecuting attorney, right? They just don't belong there. Now, if that does happen, if somebody who is where they're not supposed to be, like an innocent person in a courtroom, right, then the court is the people in the court are going to act the same, right? So it's not even if that person is either obviously innocent or obviously guilty, it's gonna be the same. For example, if a cop comes and pulls you over and tells you that he has reasonable suspicion because he's got a giraffe that can smell or that has X-ray vision, right? A giraffe, like a 12-foot tall giraffe with X-ray vision, you are going to act the same. You're going to do the exact same thing, say the exact same things, and you're going to ignore the giraffe. Literally ignore it, right? And that's what's happening here, is that Mr. Myers is completely innocent. Even all the things Rachel is explaining are all things that are that are not crimes and don't even add up to a crime in any measure of the word. But people are acting like they're supposed to do what they do. The judge is just disregarding everything she's saying and just thinks that he is guilty of something because of the dramatic way she says it or the certain words that she uses. And now look, this is how I'm going to just show you that idea. This cop pulls these guys over for speeding, gets them to gets them to admit that they were going 90 miles an hour, gets them to admit to whatever drugs they have in the car, and then takes his cat and does an exterior air sniff with a cat. All right, check it out.
So, my name is Chief Pratt. I'm with the Feline Police Department. The reason I stopped you today is for speeding, sir. Hey, where you're going a little fast?
Yeah, probably was.
Okay. Do you know what the speed limit is here?
I thought 80.
Yeah. So I ended up clocking you at 91 miles an hour before you slowed down. Okay? Does that sound about right? Okay. So, okay. Do you have your driver's license handy?
Yes.
Hey, thank you. So I'm going to have to ask you what the odor is coming out of the car here.
What's the what?
The odor I'm smelling coming out of the car.
Okay.
Do you have any controlled substances in the vehicle?
No.
Okay. Are you sure?
Yeah.
Okay. So I am with the Feline unit, with the Feline Police Department's Feline unit, and I do have my feline partner with me. So what I'm going to do is I'm going to deploy my cat around the outside of your vehicle, and if the cat indicates the odor of a controlled substance, we're going to go from there, okay?
Okay.
Does that make sense to you?
Sure.
Okay, I'll have you close the door.
Let me ask you this. What do you have? Oxycodone? That's not a controlled. That's prescription.
No, so my feline is certified to indicate the odor of marijuana, cocaine, heroin, and methamphetamine.
We're good.
Okay.
We're good.
So we'll bring the feline out. We'll go around the vehicle. His indication is he will meet.
I mean, the driver is shaking his head up and down like, oh, yeah, go ahead. They've admitted to having oxycodone. They've admitted to going 90 miles an hour. And now they're admitting or allowing a feline, a cat, to sniff the outside of their car. And they think that he said it's totally okay because it can smell heroin, meth, and whatever, blah, blah, blah. Like, they are totally cool with this. They're not laughing. They're not joking. They really think this is serious. But it's not. And this is what's happening with this court. Every court date is like a joke. It's like a bad joke.
Meow 3 times in a row. If he meows 3 times in a row, that's a positive indication, okay? That's what we're going to be looking for. I'll have you close the door and just roll the window down for me. this is Officer Frou Frou. She's been with the department for 8 years. So, yeah, she's been certified for 6 of those years. First 2 years of training. Well, you know, by law, we can only do an exterior sniff without a warrant or permission or whatever. And you did give me permission, but, you know, I'd prefer just to see outside the vehicle. So, if we hear 3 meows in a row, that's where we know we're going to have an issue, okay? Okay, well, we're going to get started here. So, she's trained in Dutch, so we're gonna use gieft. Gieft. See the interest? All right, come this way. Gieft. Okay, miss in the back there, she about wanted to climb in with you. Do you have anything you shouldn't have? Yes. No. Nothing you shouldn't have in there? No. Did you see how she wanted to come in with you, though? Yes. Okay. Do you have a lot of cats?
No.
Does she not recognize you as a cat person?
No, we don't do cats.
See how she wants to come in?
We have a dog.
Okay. You guys, I can't keep playing with you. This is April Fool's joke. There's no. I'm thinking, damn, there's no feline unit. That's fucking hilarious. I'm sorry. I've been wanting to do this for a while. There's something on April Fool's. I had to try it. Do you guys forgive me?
Yeah.
Okay.
No, I don't know yet.
Okay. All right.
That is the ultimate.
I
wish we would have a videotape.
You can get a picture with me. Don't let me forget to give your information back, though.
All right.
You see what I'm saying? Okay, and in here, most people still probably don't understand what this has to do with that. What actually happened is the exact same thing that would have happened if he had a real dog, and if he was being really serious. The exact same outcome. The people would have acted no different. He would have admitted to what's in the car. He would have, and then the cop too. The cop would have asked the lady if she was holding anything or whatever, and say, "Oh, the dog really blah blah blah." And what I'm saying is if you change the person who's in front of the authority figure, or if the authority figure changes to a goofy person, it doesn't. Your role, because you're in that situation, the role you play is going to dictate how you act, right? So if you put an innocent person in front of a jury or in front of a judge, especially a judge, then looking at the evidence and all the things that they're supposed to be looking at, they can't possibly look at because that's not what you're supposed to be. If somebody is innocent, you as a judge can't be focused on the things that got them there and why they're there. But that's what is going to exonerate them, is the fact that they're not supposed to be there. You know, so looking at the evidence, it does no good if you can't look at how they got there. And by the time you get there as an innocent person, the judge is no longer looking at that. They expect that you're there for a reason, right? For specific reasons that just got overlooked in Mr. Myers' case, or, you know, whatever, purposely ignored or whatever. But since he's in that position in front of that judge cannot look at the evidence and properly do anything with it, because the evidence they need to look at is the way he got there and the people that got him there. You know what I mean? But at this point where he is now in the system, he's far beyond looking at that. And that's why it looks so bad to them, and to us it looks like a joke, because it is a joke. But the judge, again, can't and won't look at what the reasons he is in front of him for. He just assumes that those have been followed and that has been done correctly, just like everybody in that car assumes that cat has been trained and blah blah blah. You know what I mean? But like a dog would have, you know, but instead it's a cat. But they still, all those ideas and thoughts about how that cat became a feline, or how canines become a canine, you know, drug sniffing dog, they just transferred over into that cat. When really, if they would have just looked at it and say, hey, a cat couldn't do like a cat would never go through that process with a bunch of dogs and get trained like that, because they're not dogs. But that thought that you have of dogs being able to do that, you just transfer all that, like, oh, all that's, you know, embodied in this cat. And the main thing is that it's presented by an authority figure. The cop is the one presenting and putting that out there, like, this cat can do this. You know, it's the same thing with Rachel. She's presenting the information. It's not what she's saying in what she's presenting. It's that she's presenting it. Period. You know what I mean? And again, Lane Myers is a drug sniffing cat. You know what I mean? Like, People are going to believe he is whatever that cop or that prosecutor says he is until, I don't know, until we prove otherwise, I guess. Now, they set his trial for July 21st, I think. Okay. Now, I want to offer some more information about what I think, right? And I said it in the last video that I think that the judge and that Matt Walker both have a hand in this because they're trying to get some rules changed for the Supreme Court rules changed, right? Okay. So the timeline is January 10th is like the last day to have your I guess your suggestions, right, for the rule change, right? Okay. Now, does everybody remember how William Parvin got appointed to Mr. Myers? It was when Judge Ball kidnapped him. I don't know if y'all remember that. Just want to focus on two parts: his misunderstanding of the Arizona Constitution and the fact that he said he worked for the federal courts in California in whatever year.
Experience when you had 3, my wife actually trained you in court. First, I have never said such a statement in court. To the degree that I can infer that defendant is alluding to a statement on a website that indicated to the public that I had worked for the United States District Court for the District of Arizona in 2014, worked for the federal court in the Southern District of California in 2015, back at the federal court here in Tucson in 2016, 17, 18, 19, and into 2022, at which time I resigned my position to stand for a candidate in the election as Justice of the Peace, for which this seat that I have held on and before does require proper courtroom decorum infringe upon a person's freedom of speech. The Arizona Constitution explicitly states that, quote, every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right, end quote.
It's ironic how this situation and his specific misunderstanding of what freely speaking in the Arizona Constitution means is perfectly encompassed in what happened, right? So Ball asserts that Mr. Myers is breaking a certain whatever law or rules of decorum or whatever it is by using profanity, which again, that's a whole debatable subject, by using a bad word in court. And he said he thinks that is the abuse of a right and is punishable or should be punished. Okay, that is wholly wrong. Now, what Judge Ball did, in fact, is a crime and is not protected under the Arizona Constitution, because what Ball did is used his words to actually create to have somebody else commit a crime and leave a injured person in the wake of that, right? That which is a crime. What Mr. Myers did leaves no injured person. But Judge Ball did was use his words and said, hey guys, take him into custody illegally because you can't be arrested and caged for what Mr. Myers did. So Ball created a victim, used his words, and actually created a victim because of his words. Now, somebody else committed a crime because of those words. Now, those words you are to be held responsible for those words and be, charged with a crime. That's what it means. It doesn't mean that your bad words, because Mr. Ball didn't like them, is you're responsible for the whatever punishment he decides. That's not what it means. It means if your words directly cause a crime, like, for example, if he's kidnapping somebody and caging them unlawfully, then that is not protected speech. What Mr. Myers did is just use a bad word, right? So that's where his misunderstanding comes in. Oh, sorry, I ramble a lot, but just to recap, a judge, a person used his words to get the government to cause harm to another person, right? Leaving a injured party because of the government and using his words to create that situation where an injured person is left behind. That is exactly what the Arizona Constitution and the First Amendment of the United States Constitution means when it says it's protecting us from that. That is the free speech that he needs to be held responsible for. Because if he hadn't spoke those words, no government agents would have grabbed Mr. Myers and caged him, right? That is what the Arizona Constitution is trying to stop, right? It is there to stop. It's not there to be an excuse for Mr. Myers' bad words. Also, too, statutorily and from case law, both say that if your words are likely to cause a physical altercation, then that your words are a crime. I mean, his words did cause a crime. So, I mean, technically, statutorily and case law says that he is guilty of that. You don't even need the Constitution to go that far, but whatever. I'm just explaining what he thinks is wrong. Now, he says something else that's pretty dumb here in a minute. I'm just trying to bring up their misunderstanding of the Constitution, because Rachel does the same thing in open court, directly says something about the Constitution that is just wholly wrong. So Now, listen carefully. She calls him the accused, which is correct, but then refers to Shannon as the victim, which is incorrect, which is what would happen after Mr. Myers is convicted. Then she would be called a victim, but she's using that terminology right now to a judge to bias the judge.
Yes, Your Honor.
And in notice file, the accused record of arrest and convictions, as previously noted, he does have prior convictions, which makes him facing mandatory prison time, and he has a lengthy arrest history. And so, for all those reasons, we are asking for these more stringent release conditions because I think it's necessary to protect the victim and others in the community and other people connected with this case. And then I also want to point out the Arizona Constitution 2.1, the Victim Bill of Rights. The victim is to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal process. And just from him getting a summons, he immediately targeted again the victim and immediately was calling upon third parties to engage in harassment, intimidation, and abuse towards this victim. And so these release conditions are necessary to protect the integrity of this case, to protect the integrity of...
Okay, I just wanted to point out her severe misunderstanding of what she read in the Constitution, because the Victims' Bill of Rights is meant to protect them against harassment, abuse, and intimidation from the person that has been convicted of torturing or whatever, hurting or harming them in the past. A court needs to previously have convicted this person of this crime against that very victim for her to even bring that up. So she's misunderstanding what it is, again, that's said in the Arizona Constitution, just like Ball did. Now, she goes a step further, and then she claims that it is the reason she's asking for these conditions is to protect the integrity of the judiciary and to protect the integrity of their case. It's not. It's to protect the public from the harm that could come from this specific person, when she's claiming it's to protect the integrity of some fictional thing, right? It's absolutely ridiculous, this lady's misunderstanding of what she's doing. Now, Parvin's thoughts on the violation of rights, constitutional rights. Let's see what he thinks about it. Who wants to bet that it's a complete misunderstanding?
This case is pending. Again, that's not a violation of rights. It's an exchange for not being in custody.
Okay, maybe a violation. So we're not going to keep you in a cage, and we're going to set you free. Okay, agreed. That's fine. But then, and Mr. Myers even says, I agree. And then right after that, then he says all the stuff that does make it a violation of constitutional rights, because upon that release, if all your rights are stripped from you upon that release and you can be arrested, then it's the same thing as being in jail. So like, listen how smooth this is. Right after Mr. Myers says, I agree, then he says all this other shit, like take down all your videos, don't get on the internet. Like it's so bad, dude. These three people are so bad. And like I said in the last video, he did that because there isn't a victim right now. So there's no possible way he could have taken down anything related to her, because there is no her to be related to. Now, here's where I'm going to start this idea. So all three of them have a severe misunderstanding of the Constitution. That has to be, they had to have, the three people in their position, like a judge, a prosecutor, and a defense lawyer, don't all have the same misunderstanding of the same state's constitution without somehow having, I don't know, shared thoughts with each other, like, or, been around each other in the same room or talked about it, because they obviously, their lapses in understanding of the Constitution specifically put Mr. Myers in jail. Like, you know what I mean? More specifically, they're keeping him in jail. There are specific misunderstandings, from each of their viewpoints was what's keeping him in jail.
That's it for today then.
Thank you. Thank you, Your Honor.
What could happen if he were to violate a condition of his release?
There could be a motion to modify and your release.
Can be taken into custody, all right? I think that's been clear.
Could do both. All right, thank you, everybody.
Thank you, Your Honor.
Where do I go?
Hold on. I'll walk you to the second floor.
Okay.
All right.
But it's not clear at all. And that was the only point of an arraignment, is to make that clear. But anyways, moving on. So like we heard Judge Ball say, he was in the Southern District of California for 2000, blah, 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 2000, blah, whatever he said. And then So I'm thinking about it, and I don't know where Rachel came from. So I just looked in, typed her name in a few search engines and whatever, and I found this. So it seems like Rachel Lynn Stiles is a domestic violence plaintiff in a civil case against some guy named Paul. And where was that filed? A place called Placer County, California. California, okay. So what about Parvin? Does he have some ties to California, maybe, possibly? Well, let's see. William J. John Parvin, age 40, resides in Tucson. He's lived in Henderson, Nevada, Stevenson Ranch, California, Santee, California, and Canyon County, California. I actually have buddies that live in Santee. Santee's a pretty cool place. But anyways, so all three of them have recent ties or grew up in California. And also, too, you know, Ball is a religious guy, and Parvin went to a Catholic college. I don't know about Rachel. I didn't go that far, but I just went as far as they're all tied to California somehow. And then Ball's statement.
That indicated federal court in the Southern District of California in 2015.
Okay, which brings me to my thing. I think that the whole thing that's happening to Mr. Myers is orchestrated, and I think it was supposed to happen whenever he got wrongfully arrested with Ball, because there was no video of it, right? Just like they're doing now. They want no proof of it on video, and he actually arrested him and had him taken to jail, right? So that's, I think, when it was supposed to happen. So if I'm right, that happened on December 2nd, right? So by January 10th, which is the last day that they have to get in their petition. And of course, Lower Conover is backing this whole Rule 122H rule change where it would just basically outlaw cameras, period. But of course, that bitch is all over it. But anyways, not the point. So basically, public comment, or comments from the public, are submitted no later than May 1st, 2025. And reply by the petitioner must be submitted no later than Monday, June 2nd. So that's the petitioner would be Matthew Walker, and he actually has to reply to what we say on by June 2nd. And so here it says he's got 30 days after the whatever to reply. And then in order for it to be seen here at the annual rules conference in August or September. So yeah, have 5 days of a trial. They convict him. So that's like the 26th, and then 30 days for sentencing or whatever. So right around the time, and of course, the Supreme Court is not going to review it right on August 1st because they gave themselves a whole month for a buffer. So he's going to be freshly serving a fresh sentence at the very time they're going to review the rule, and they're going to have all that footage of the courts, not Mr. Myers, the courts disrupting their own court sessions to talk about videotaping. They're fucking idiots. That's what I think. Because think about it, if at the rules conference, right, and he's attached his files that have like all talking shit about Mr. Myers and saying, oh, look, we have an example of this right here, but then it shows 17 dismissals, and then they're going to think, well, fuck, the rule's working just fine, you know what I mean? Or it shows 17 felony charges and him still in jail pending sentencing. And also, too, now Shannon Walker really gets to be a victim, and oh my God forbid if she starts talking, dude. Jesus Christ, man, the shit she's going to say, the lies she's going to make up about, oh my God, dude, this just cannot happen. And if you remember at the arraignment, William Parvin was appointed as if he was some new thing that we didn't know about, because otherwise she would have said counsel of record instead of I'm appointing you an attorney. It would have been on counsel of record.
Using profanity in the courtroom during a legal proceeding is an abuse of the right for which the
court will hold the person responsible
by finding them